All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good afternoon, everyone. Court officer, could you call the case, please?
Good afternoon, Madam President. This is the situation in Darfur, Sudan, in the case of the prosecutor versus Abdallah Banda Abakar Nourain. Case reference ICC 0205-0309. And for the record, we are in open session.
Thank you very much, court officer. I will now take the appearances, please, beginning with the Office of the Prosecutor. Ms. Brady.
Thank you, Madam President. I appear today with Senior Appeals Counsel Helen Brady, Kubudu Sachitanandan Trial Lawyer, Niftiru Appeals Counsel, Associate Trial Lawyer Rachel Mazzarella, Catherine Dunmore, Trial Lawyer, Carmen Garcia Ramos, Case Manager, and I am Cara Prunk-Jordan, Senior Legal Coordinator for the Office of the Prosecutor, representing Deputy Prosecutor Khan, who unfortunately can't be here today.
Thank you very much. I will now take the appearances for the defense, please. Chief Tucker.
May it please your honors. My name is Chief Charles Achaleke-Taku, legal counsel of the Banda. I appear today with my learned colleague and co-counsel, Mr. Thomas Obof, and my case manager, Ms. Judith Akebe. Thanks, Your Honor.
Microphone, please. Chief Tucker.
Yeah, I'm sorry, my lord. General Banda is following the trial by video link from Khartoum. General, welcome, and I apologize for not mentioning your name earlier. I think your presence here today will also is very, very important, and for me in particular. I really cherish that you should be here and listen to your lordships by serving the prosecutor and the victims. Thanks.
Thank you. The Chamber notes the appearance of Mr. Banda 12 years after his failure to appear in the issuance of an arrest warrant. I now turn to the legal representatives of victims, please, for the appearances.
Oui, bonjour, je suis Maître
Good afternoon.
Hélène
I
Cissé,
am Hélène
conseil
Cissé,
principal.
Principal
J'ai
Counsel,
avec moi Maître
and I am
Jens
flanked
Dickmann,
by Mr.
conseil
Jens
associé,
Dickmann,
et
Associate
Madame
Counsel,
Evelyn
and
Ombeni,
Ms.
case manager.
Evelyn Ombeni, Case Manager. Thank you.
Thank you, Ms. Cissé. I now, the registry, please.
Madame la Présidente, Messieurs les juges,
Madam President, Judges, good afternoon. The registry is represented in the absence of Marc Dubuisson, Director of Services of the Court. We have colleagues from the Unit for Judicial Operations, Caroline Bosset, and we have Charlotte Dahuron.
Thank you very much. This hearing is scheduled for a single session this afternoon, and it is a public hearing in open session. The purpose of this status conference was set out in the Chamber's decision on the prosecution's request for reconsideration and the defense's request to convert the warrant of arrest into a summons to appear. As stated in paragraph 29 of that decision, the Chamber, in the circumstances, directed the prosecution to provide public notice of its withdrawal of the charges, together with the reasons for that decision. Following the prosecution's statement, the legal representatives of victims and the defense will have an opportunity to make oral observations should they wish to do so. I wish to emphasize that the parties and the participants must restrict their submissions and observations to this procedural matter before the Chamber this afternoon, which is the prosecution's withdrawal of the charges. The Chamber will not entertain statements or observations relating to substantive matters on the case. With those remarks, we will now hear from the prosecution.
Thank you, Madam President, Your Honours. I will begin with a short introduction, and then Mr. Sachitanandan will provide a more detailed overview of the reasoning of the prosecution. And after this, I will briefly conclude the remarks of the prosecution. Madam President, Your Honours, the prosecution appears before the Chamber today to give notice publicly that it is withdrawing the charges against Mr. Banda. A notice of withdrawal was filed this morning. We do so because it is the prosecution's carefully considered view that the evidence no longer presents a reasonable prospect of conviction at trial, and that the evidence has deteriorated so much so that it even no longer demonstrates that there are substantial grounds to believe that Mr. Banda committed the charged crimes. This is not a decision that has been taken lightly. It is a decision grounded in the legal and ethical obligations that define the office and in our continuing duty to act independently, fairly, and in the interests of justice. The pre-trial chamber confirmed the charges against Mr. Banda 15 years ago in 2011. The prosecution has since undertaken a continuing and rigorous reassessment of the evidentiary record, exhausting all reasonable investigative avenues available to it. As Mr. Sachitanandan will explain further, this case and the decision to withdraw have been the subject of careful internal review and consultation across the office. The decision is the product of thorough professional analysis, considered judgment, and faithful adherence to the prosecutor's statutory responsibilities. Having undertaken that assessment, the prosecution no longer has confidence that the charges continue to be supported by the evidence, or that it can discharge the requisite burden at trial. The prosecution has a duty to proceed to trial only where it genuinely and reasonably believes that the evidence establishes guilt beyond a reasonable doubt. Moreover, the prosecution owes an equally important duty to victims not to foster expectations of a conviction where, following careful reassessment, the office no longer has confidence that the evidence can sustain one. To continue in those circumstances would neither serve justice nor honour the trust that victims have placed in this court. Your Honours, the prosecution fully recognises the impact that the withdrawal of the charges will have on victims and affected communities. We also recognise the Chamber's view that this case could appropriately proceed to trial. We respectfully acknowledge that difference of view. However, the Rome Statute entrusts the prosecutor with an independent responsibility to continually assess the evidentiary basis of every case and to proceed only where the legal and ethical standards governing this office continue to be satisfied. The integrity of the criminal process requires prosecutors to act with objectivity at every stage of proceedings. In this stage of proceedings, we have a duty to pursue cases only when we believe that the charged crimes can be proven beyond reasonable doubt. Our duty is not simply to prosecute. It is to ensure that prosecutions are pursued only where they can be properly and fairly sustained. And it is for these reasons that the prosecution withdraws the charges against Mr. Banda. I now hand over to Mr. Sachitananda.
Madam President, Your Honors, pursuant to your instructions, I will set out the reasons underpinning the prosecution's withdrawal of charges against Mr. Banda. I will discuss principally the main evidentiary developments and the related reasons why the office has maintained that the continuation of proceedings would no longer be consistent with its obligations under the Rome Statute. You will recall, Your Honors, that once the charges were confirmed in this case, the proceedings advanced to the trial stage and trial was initially scheduled to commence in 2014. However, Mr. Banda failed to appear pursuant to the summons issued by the court, and the trial chamber then issued a warrant of arrest in September 2014. And Mr. Banda remained outside the court's custody thereafter. Importantly, even though Mr. Banda remained at large, the office continued to discharge its obligations under the Rome Statute. The prosecution continued to investigate both incriminating and exonerating evidence or circumstances, remained in contact with witnesses wherever possible, and continually reassessed the evidentiary foundations for the prosecution case. Your Honors, during these reassessments, a number of problematic developments arose in the evidence. These developments principally affected one key aspect of the prosecution case, that is to say, the issue of whether Mr. Banda was aware of the factual circumstances establishing the unlawful nature of the relevant attack. These evidentiary developments are as follows. Firstly, the loss of witness P441. Your Honors will recall that P441 occupied a significant position within the prosecution case because the witness provided evidence concerning Mr. Banda's position of authority within the attacking force, and also regarding Mr. Banda's access to information regarding the planning and execution of the attack. Later prosecution investigations, however, revealed that P441 had engaged in serious dishonest conduct. As a result, despite the importance of his evidence, the prosecution determined that it could not rely on such testimony, since such testimony could not be regarded as credible or reliable. Accordingly, P441's evidence could no longer form part of the prosecution case. Similarly, Your Honors, there was the loss of the evidence of witness P477. P477 had also occupied a central position within the prosecution case, in that the witness provided direct evidence concerning the purpose of the attack and Mr. Banda's position of authority. His evidence supported at that time the inference that Mr. Banda possessed the requisite knowledge of the unlawful nature of the relevant attack. However, Your Honors, during renewed contact with the witness, significant credibility concerns arose. Ultimately, the witness refused to further engage with the office. Here again, the office therefore concluded that P477 could no longer be relied on as a credible prosecution witness. The consequence hereto was the loss of one of the principal sources of evidence capable of establishing the reason for the attack, the unlawful nature of the attack, and Mr. Banda's knowledge of its unlawful nature. Your Honors, the prosecution did not accept these developments passively and sought to remedy these weaknesses. To do so, the office undertook extensive investigative efforts. Previously interviewed witnesses were recontacted where possible, and investigators systematically reviewed available new leads. There was a comprehensive mapping exercise which identified known participants in the attack, and potential witnesses were identified. These potential witnesses were approached wherever possible, and in particular, individuals believed to have key evidence relating to the planning of the attack were sought. a number of these new witnesses were interviewed. Madam President and Your Honors, it is at this time or around this time that the investigation took another important turn by way of the location of witness P512. P512 had not been interviewed during earlier stages of the investigation, despite prolonged and extensive efforts to find him. However, the office was finally able to secure his evidence and found that he was a credible witness whose account materially altered the evidentiary picture. Whereas the prosecution had previously relied upon the absence of any attempt by the attackers to locate the Government of Sudan representative within MGS Haskanita as supporting its case theory, by contrast, P512 described attackers as actively searching for this Government of Sudan representative, Captain Bashir. This evidence substantially weakened the prosecution's previous inference regarding the purpose of the attack and introduced a credible alternative explanation. Overall, Your Honors, viewing in retrospect this process of investigation or reinvestigation, the efforts of the prosecution to fill the gaps in its case ultimately proved unsuccessful. Key potential witnesses were either deceased, could not be located, declined to cooperate, or were unable to provide evidence capable of remedying the identified deficiencies. In addition to these challenges in the context of newly identified witnesses, in the 15 years that had elapsed since the pretrial chamber had confirmed the charges, several of the witnesses relied on at the confirmation stage had also become uncontactable, uncooperative, or otherwise unavailable. Of the confirmation witnesses that remained available, some presented credibility and reliability issues, and the prosecution necessarily had to exercise caution in relying upon their evidence, especially when they provided the sole or main evidence on a given fact. Your Honors, bearing all of these factors in mind, and having undertaken a significant effort to reinvestigate the case, the office carried out an internal evidence review in February 2023. This review included experienced prosecutors, investigators, and analysts from across the office of the prosecutor. After extensive review and consultation, the resulting assessment, completed in March 2023, concluded that there was no reasonable prospect of convicting Mr. Banda on the available evidence. Given the significance of this finding, the office considered it appropriate to introduce an additional safeguard. Accordingly, Madam President and Your Honors, Deputy Prosecutor Nazat Khan instructed that an independent external review take place. Thereafter, an experienced external advisor reviewed the evidentiary record and submitted his report in September 2023. In his report, he also independently concluded that the probability of securing a conviction was low. Your Honors, it is against this backdrop, after extensive efforts to reinvestigate the case and equally extensive efforts to effectively analyze the evidence, that the prosecution finally, in October 2023, sought authorization from this chamber to withdraw charges against Mr. Banda. Your Honors will recall that the chamber first rejected the application in October 2023 and invited further submissions. Among the reasons provided by the chamber at that time were, inter alia, the fact that Mr. Banda remained a fugitive from justice. Following additional proceedings, the chamber once again declined to authorize withdrawal in March 2024. Your Honors, with regard to the period after such rejection, the office did not cease investigations. Rather, it continued searching for evidence capable of overcoming the deficiencies identified during its review. Those further efforts, however, ultimately reinforced the officer's conclusions. Your Honors, two additional witnesses, that is to say P1840 and P0308, were identified as potentially capable of providing evidence, direct evidence, concerning planning meetings which may have been relevant to proving the unlawful nature of the attack and Mr. Banda's alleged knowledge of such unlawful nature. However, once interviewed in late 2025, both witnesses proved unable to provide the anticipated evidence. Neither had attended the relevant meetings, neither possessed direct knowledge of the planning process of the attack, and in addition, one witness relied upon hearsay evidence or hearsay information from unidentified sources, and the other presented additional reliability concerns. Therefore, far from strengthening the prosecution case, these interviews confirmed that the remaining reasonable investigative avenues had effectively been exhausted. Subsequently, Your Honors, you will recall that in October 2025, the Counsel for the Defense submitted a request to convert the arrest warrant for Mr. Banda to a summons to appear. At this point, the prosecution assessed that Mr. Banda's appearance before this court was potentially imminent. The office in this context recalled the Chamber's earlier guidance that once Mr. Banda's appearance had been secured, relevant matters could be reconsidered. The office again at this point bore in mind the exhaustion of investigative remedies as represented by the interviews of P1840 and P308. Thus, in November 2025, the prosecution renewed its request to the Chamber to reconsider its decision not to authorize the withdrawal of charges. The prosecution at that time was of the view that, firstly, compelling Mr. Banda to appear for trial when the prosecution had already concluded it could not prove the charges would amount to an injustice. The prosecution was also of the view at that time that it would also create unrealistic expectations amongst the victim community, this community who had been waiting for over a decade for the trial to commence. And indeed, Your Honors, as the prosecution appears before you today, it remains still of that view. I note, Your Honors, that it is subsequent to these submissions of the prosecution and other parties and participants that in June 2026, the Chamber authorized the prosecution to withdraw the charges without prejudice to future proceedings and to give public notice of such withdrawal. Madam President, Your Honors, this concludes my provision of detailed reasons for the withdrawal of charges. I now hand over, or rather hand back to Ms. Pronk-Jordan.
Madam President, Your Honours, as you heard in the overview that was just provided, since the confirmation of charges against Mr. Banda, key prosecution evidence has deteriorated, credible exculpatory material has emerged, and renewed investigative efforts have failed to restore the evidentiary foundation of the case. As a result, the prosecution has concluded that it can no longer responsibly maintain its case. The prosecution respectfully takes note of the critical observations by the Chamber in its decision to authorize the withdrawal of charges. However, as mandated under the Rome Statute, the prosecution's responsibilities require it to independently assess whether it remains proper to continue advocating for a conviction. Moreover, while the assessment of witness credibility and reliability at trial is ultimately a matter for the trial chamber, the prosecution cannot knowingly present evidence from witnesses whom it no longer considers sufficiently credible or reliable. Today, the prosecution is not seeking the easier course, but the course that the law and our professional responsibilities require. In doing so, we fulfill our duties to the accused and to the victims and seek to uphold the integrity of these proceedings. Justice demands not only that serious crimes be prosecuted where the evidence permits, it also demands integrity from the office to discontinue proceedings where, after careful and exhaustive review, the legal and ethical standards required of this office are no longer met. The prosecution's withdrawal of the charges is without prejudice to bringing new charges on the same or similar facts should we obtain sufficient evidence in the future. Because our overall work in the situation in Darfur continues. It continues with our work in cases pending before the court over past atrocities, and it continues in our ongoing investigations into current crimes in Darfur. Throughout this investigation, the office has met with victims and survivors. We have listened to their accounts, learned of the profound suffering they have endured, and witnessed the remarkable courage they have shown in coming forward and engaging with the office. Nothing in today's submissions diminishes their suffering, the seriousness of the alleged crimes, or the importance of their search for justice. Thank you.
The chamber takes note of the statements of the prosecution. Next, we will hear the observations from the legal representative of victims.
Your Honours, may it please the Court, I will start the oral observations for the legal representatives of victims to be continued with Principal Counsel. Your Honours, today this chamber is asked to note the prosecution's withdrawal of charges against Mr. Banda and is asked in consequence to terminate the proceedings in this case. But respectfully, it is not merely terminating a case. By doing so, it is closing a chapter in the lives of men and women who have waited for almost 19 years for justice. For them, for the participating victims in the Banda case, this is not a procedural application. This would be, in fact, the end of hope. Hannah Arendt, based on her own experience as victim of fascism and her own political theory, famously described, quote, the right to have rights, end of the quote, as a central, in fact, essential human right. All systems working under the rule of law like this court are bound by this human right and its promise. Our clients believed that the International Criminal Court represented precisely this promise. When every national institution failed, when no government protected them effectively, when violence had erased the health, the life of the beloved sons, the husbands, the brothers, and their dignity, they believed over all the years that international justice still recognized them as human beings whose suffering mattered. Today, many of them will inevitably ask us, did we really have that right? Or was it only an empty promise? Justice has always required patience, sometimes extraordinary patience. But justice also requires perseverance from all actors. In this context, the legal representatives of victims remind the Chamber to its public decision on the prosecution's request for finding of non-compliance from 19 November 2015. On 16 October 2015, the Office of the Prosecutor requested that the Chamber issue a finding of non-compliance against the Republic of the Sudan in the Banda case. Prosecution submitted that Sudan has failed to implement the court's order to arrest Mr. Banda and that there is no prospect of Sudan complying with the arrest warrant of its own volition. On the 9th of November 2015, the legal representative of victims filed a submission supporting the prosecution's request with 4 confidential annexes containing letters, handwritten letters from represented victims, where they supported the relief sought as quoted in Chamber's decision in footnote 3. Legal representatives of victims had collected several authentic personal handwritten statements. The request was granted and the decision was transferred to UN Security Council. So the individual pleading of the victims is part of the record of this case. The victims remind us, especially today, international criminal justice exists precisely for those moments when success appears impossible. Your Honors, every judicial decision speaks also beyond this courtroom. Every decision sends messages, if we want or not. What messages will today's decision send? What messages want we to be sent? The first message may sound cynical. It may be heard by defendants at large. It may be heard by suspects who consider escaping justice. The message could become painfully simple, and it's, if you can evade arrest long enough, justice eventually disappears. Flight may pace, time defeats accountability. That is a very dangerous lesson of today. But it must be said loud. Justice delay may be justice denied. A second message reached beyond this court. It reached the African Union. The participating victims in the Banda case have been African Union peacekeepers or working for them, heavily wounded and handicapped for life, and the families, widows and children of peacekeepers who have been killed in the Haskanita camp on this terrible day in September 2007. Brave men served under African Union mission, risked and sacrificed their own lives to protect civilians in Darfur and fighting for peace and security in the region. What are we telling the African Union today? Is the ICC a place to effectively protect African Union peacekeepers against international crimes? What do we tell those brave soldiers believing that international justice stood behind their sacrifice? And finally, Your Honors, talking about messages, let us send out a message to the victims today. Let us remember the participating victims. Let us send a message to them today, not as files or witness numbers or procedural participants. The participating victims in the Banda case, they are the true heroes of these proceedings. They testified, they cooperated with the prosecution and the court. They relived unimaginable suffering. They believed in law instead of revenge. Their patience has been greater than ours. Their courage has been greater than ours. And their faith has certainly been greater than ours. Your Honors, history rarely remembers procedural orders. History remembers what institutions stood for. Nuremberg was never only about convictions, whereby the first judgment was rendered on 1st October 1946, 80 years ago this year. Nuremberg was about declaring that law would replace impunity. this court carries the same responsibility. Whether today's application is granted or not, history will ask a larger question. Did the International Criminal Court in this historical situation remain faithful to its promise that no victim would ever again stand completely alone? That is a question which will echo far beyond this courtroom. On behalf of our clients, the 103 souls from 6 different African nations, the participating victims in the Banda case, the legal representative of victims wish simply to express our profound gratitude to everyone who has devoted years of their life to this case, the registry, the court, and particularly also the office of the prosecutor. Their work during the past years honored the victims. But I address the prosecutor. You will only truly honor the victims if your work continues also with regard to the Haskanita incident, because justice delayed may wound hope, but justice abandoned wounds humanity itself. So there is one message of the participating victims to us in this courtroom today. And this message is with the words of the late Benjamin Ferencz, words which should continue to inspire every institution committed to international justice. Never give up. Never give up. Never give up. May it please the court. This concludes my own observations. I respectfully hand the floor over to Principal Counsel, Maître Hélène Cissé. Thank you.
Merci. En fait, nous avons tenu à ce que
Ms. Cissé,
l'accent
thank you.
sur les souffrances réelles, l'attente, les espoirs,
We want to lay emphasis on the
sur le débat technique.
hopes of the witnesses and their expectations before addressing the more practical aspects. We have the impression that the victims have become the orphans of international criminal justice, notably in this case. Now, before anything else, I would like to thank this chamber for having invited the legal representatives of victims to attend this status conference to present their views on the application to withdraw the charges in this case, and also to address the very specific circumstances of the case. We take note of the Chamber's efforts to make sure that the victims may actively participate in this case, and that since 2011. Now, I would like to add a few words following on from the excellent presentation of the context in which the victims find themselves by my colleague, by saying that the right to have rights entails above all the right to give genuine and practical meaning to one's rights in light of one's personal interests as a victim at each stage of the proceedings. Now, these rights are set out in Article 68, paragraph 3 of the Statute of Rome, and I won't quote it, but I simply wanted to say that in requesting the withdrawal of the charges, all charges by the prosecutor, which has been authorized by the Chamber, we see in that a procedure which is at the, or touches the very heart of the personal interests of the victims. And this even if in the common law system there is a tendency to consider that adversarial proceedings lie in the hands of the prosecutor, and the prosecutor has exclusive rights, and victims have little to say. Now, the Chamber has pointed out that the system of the International Criminal Court is a system which is universal and which does its utmost to incorporate two systems, the common law system, which is an adversarial one, and the more continental system, the civil law system, which is more investigative, inquisitorial by nature, but which also provides additional assurances and safeguards to victims, notably when it comes to the hearing of a case. Now, this chamber has authorized the prosecutor to withdraw all charges against this accused person. We have said before, and we repeat it here, that the automatic follow-on consequence is that the witnesses are denied their right to a public trial. And that's at the heart of the matter. And it is on this point that the legal representatives of victims make their views known. We note that this chamber has innovated with respect to prior case law. It has chosen not just to examine the practical aspects of a possible withdrawal of the charges, but rather has laid great emphasis on a very important point. And I wish to underline this. In a succession of decisions by this chamber, the chamber has said things which the prosecutor continues to gloss over. The chamber has authorized the prosecutor to withdraw the charges but has referred in its decision and in its decision of October 2023 and March 2024 has said that it was unjustified that the withdrawal of the charges would lead to a failure to hear the case in open court. In June 2026, the chamber has said that it did not agree with the prosecutor and recalled that there continued to be much evidence supporting the charges and leaving the door open to a trial. Now, we haven't heard anything more about that today, but to our minds, this is key. We find here the charges being withdrawn despite the fact that the chamber, which has been appointed, sees the basis for a trial. Now, what are the reasons provided by the chamber? And here we see something which is particularly problematic. The chamber has repeatedly said that it does not agree with the office of the prosecutor, given that there is a tremendous amount of evidence which still supports the charges. And I would recall the various statements made by the trial chamber, the pre-trial chamber, the October 2023 decision, the decision on the motion for reconsideration. So how is it that the chamber has come to authorize the withdrawal of the charges? Well, the chamber provides the following reasons, and these reasons have led to simple disbelief on the part of the victims. The chamber believes that there are charges, but that the fact that the prosecutor has decided not to present its case has automatically meant that the rights of the victims are violated. The impact of this denial of justice and the denial to the victims of a public trial means that there is no option or no possibility of a trial, and this simply because the prosecutor has chosen not to proceed to trial, because the prosecutor believes that the charges are not sufficient to arrive at a conviction. We see in this a simple lack of respect and a failing by the Office of the Prosecutor in its duties and obligations under Article 54 of the statute, which have been recalled by the Chamber. Now that article is key here, and not Article 60 of the Office of the Prosecutor's regulations, which was not even taken into account by the Chamber. That article says that the prosecutor shall investigate or shall extend the investigation to cover all facts and evidence relevant to an assessment of whether there is criminal responsibility under the statute. And this in particular with respect to charges brought under Article 8 of the Rome Statute. And this is of the utmost importance. It is important here to highlight that even in a system which for us as victims or as representatives of civil law systems, or for myself in the role I played in Hissène Habre's trial, that we find here a situation where evidence is available to the Chamber regarding these atrocities perpetrated against soldiers of the African Union, which is before the Chamber, but shall not be litigated in court. The right to a trial is primary for the victims, not the various debates which take place prior to a trial, but rather the absolute right to have their day in court, to have a litigation of the case in open court is here denied. By requesting the withdrawal of all charges, the prosecutor has not aired its position regarding this right to a trial. Not at all. No, the prosecutor simply tells us that he believes that there is not enough charges to obtain a conviction. But what is the duty of the prosecutor? The prosecutor is first and foremost to prosecute a case. The prosecutor has his obligations under Article 54 of the statute. The prosecutor says that he cannot present his case, but it is the very role of the prosecutor to appear in court, to play his role, to defend his positions, to air his findings, even if he is of the view that the charges may not be upheld at the end of the day. In many jurisdictions, in many courts, the prosecution nonetheless would present its case. Here, the situation is the same. Can a prosecutor choose to bring to an end any trial because the prosecutor feels, oh, perhaps my evidence at the end of the day is insufficient. No, the prosecutor must assume his responsibilities. He must appear in court. He must present his findings and his views, even if those views tend to say that the evidence may not be sufficient. There are other parties, there are other participants who may also address the court and who will want to remind the Chamber of its responsibilities under Article 64, that it is the Chamber which determines the facts of the outcome, not the prosecutor. The prosecutor has the duty to present the case. It is therefore with disbelief that the legal representatives of the victims and the victims read the decision of the Chamber. The Chamber said that there is no logic, no basis, no raison d'être to proceed to trial if the prosecutor doesn't wish to do so, refuses to do so. So basically, the victims cannot accept this decision, cannot understand this decision. The fact that there shall be no trial simply because the prosecutor feels that he doesn't have a sufficient basis to uphold the charges. He says his charges are insufficient. Now, because the prosecutor feels that he doesn't have the wherewithal to present or defend his case, we are all left behind. Despite the fact that victims have a right to an airing of the facts, the presentation of the evidence, the presentation of the context, they have a right to have their day in court, which is key to the operation of any and every court. Indeed, the International Criminal Tribunal for Yugoslavia and the International Criminal Tribunal for Rwanda have issued decisions stating clearly that full effect must be given to the rights of victims. And even if it is not explicitly stated in the basic text underpinning this court, it is vital to the functioning of the court to do what it must. Any court may innovate, may create jurisprudence, and this court too. So the issue is that we find ourselves presented with a situation. The prosecutor doesn't address the aspect, but the court itself believes that there is a sufficient basis to go to court, but Article 60 will not be put into effect. So here we have the Chamber, which has confirmed charges and believes that there is the wherewithal to hold a trial, but that trial will never take place because the prosecutor refuses to assume his responsibilities. The prosecutor should appear in court and present his case. The victims would also address court. There are a number of victims which can shed light on the facts and the circumstances of the mission. Victims, including people who were operating the radios, who knew exactly what was happening at that time. They too could have played their role. And so it is that the victims cannot understand the reasons provided by the Chamber for authorizing the withdrawal of the charges. The reason being because the prosecutor doesn't want to. He doesn't want to present his case. It's incomprehensible. How could the rights of victims simply be done away with? Simply because the prosecutor does not want to justify his position in open court. And so it is that we say that here there is an error in the reasoning provided. We see nowhere in the Rome Statute a provision which allows the prosecutor to bring to an end a trial before it has started. The public has tremendous expectations of this court, as do the victims, of course. And so it is, we believe that the court has erred, and we believe this based on the reasons which have been provided for its decision to authorize the prosecutor to withdraw the charges. No, there should be a trial. The victims should be allowed to present what they have to say in court. It is true that the prerogative lies with the prosecutor to prosecute, but others have the obligation to apprise themselves of the facts in a holistic fashion and then to determine where responsibility lies or does not. The victims have the strongest of concerns. All of the arguments which have been put by the prosecutor today we have heard nothing new today with respect to what was considered by the court in its decisions of October 23 and March 24th, other than 1840, that is to say P 1840, and one or two other victims that were referred to today. The victims believe that these matters should have been debated in court. We do understand that the Chamber sees here a possible violation of equity, a fair trial. The victims or the prosecutor has said that he does not wish to appear in court. He does not want to try the case. But there is the law, there is the statute, and there are the rights of the victims. In the document containing the charges, the prosecutor repeats that given the relatively modest number of victims involved, and that this not being a mass crime, but rather a crime of the utmost importance when it comes to peacekeeping. All victims have the same value, as do all human beings. And given the grave infractions of international law being perpetrated day in, day out, it is of the utmost importance that the International Criminal Court ensures that this case is heard.
And we seek from the Chamber authorization to submit an application for reconsideration as a result of an error in reasoning, because we see nowhere in the rules of procedure the possibility to hold a trial simply because the prosecutor is no longer confident. They should state that position. In our view, there is injustice. And I said I was so shocked to note not a word mentioned about justice for the victims and the fact that they were being denied a right to a trial. There was only care taken of the position of the prosecutor, and yet this is the prosecutor's duty. These are the rights of the victims to trial, and that is what this is about. So I wish to say we therefore seek authority to submit an application for reconsideration, and we wish to be given a timeline so that we may provide all necessary material to convince the court of the merits of that application. Secondly, as I was saying earlier, the Chamber's motivation must be recalled, and also the creative power of the Chamber with a view to creating matters, and yet that is the truth. And so we ought to be authorized to explain that there is merit to reconsidering the decision to hold the right to a process simply because of the views of the prosecutor, who must account for themselves and point to the technicalities that make it impossible to have contact with the government of Sudan. We recommend that reconsideration be granted, and to further indicate that there is nothing in the texts that would allow the prosecutor to put forward this position. I'd like to conclude as follows. As regards the explanations, as regards this particular dossier, I am certain that with regard to redactions, what is the purpose of redactions? They're intended to protect the lives, moral and physical health of victims and witnesses. Therefore, these reductions must be directly linked to risks to victims. But in many instances here, there was no such risk. What there was a willingness or determination to safeguard cooperation, which is all well and good, as there are negotiations between government and authorities. That is fine, but to conceal information from victims on a situation that is so fast evolving, and we do not even know when that was done, because in 2022 and 2023 there was still reason, as argued by the prosecution, not to halt the warrant process. So the idea of the redactions is to protect witnesses and victims from concrete danger, but not to ensure that the public and victims cannot understand developments in the case, and to understand why the prosecutor has changed its position, why initially the government of Sudan was treated as a criminal. It has always maintained, and indeed it has always been made public, and it is public knowledge that General Banda was a general. That was public knowledge. You only need to look this information up on the internet. Everyone is aware that he was a general. How many bloody rebellions or wars have taken place in Africa involving governments and rebels and ended in negotiations, and then all of a sudden the law is suspended. The accused then turns into a victim, and yet there are people who actually lost their lives, who've lost their minds and lost their income and
constraints of this hearing and the subject matter, and you're straying far from them at this point. So I would please encourage you to, I appreciate the importance of your observations and you're speaking on behalf of victims, but I would ask you to bring your remarks to a conclusion. I believe you've very thoroughly presented the position of the victim, so I'd ask you to bring this matter to a conclusion. Your remarks, please. Thank you.
Je vous remercie, Madame.
Thank you, Madam President, and I apologize profusely. It is just that when one is in daily contact with the victims, sees how they suffer, it is hard. I will focus simply on withdrawal of the charges, but fully on the issue of withdrawal of charges. I therefore conclude, I reiterate my apology, but once again, I focused on withdrawal of the charges. Thank you, Madam President.
Merci beaucoup, Monsieur Sissi, and I thank the representatives of the victims for their representations today on behalf of the participating victims. We'll now turn to the defense.
May I please the honors, I will respond to some of the points, raise several points, and thereafter I will ask my co-counsel, Mr. Thomas Oboff, also to make some brief submissions before we conclude. Your honors, when I came here today, there are problems I did not anticipate. You heard very much about the African Union, and I can say respectfully that we at the African Union, being the victims of Westphalian order, the Rome Statute became the very first independent treaty that we joined as subjects of international law, and we guard that jealously. And obviously, the African Union cares very much about what's going on in Darfur and peacekeeping operations generally. I've been in all the battlefields, and for one of the first counsel from the ICTRO to Special Court of Sierra Leone to the ICC Central Africa, I've also advised governments in the continent as a very senior lawyer in the continent and a traditional chief, and one of the key significant personalities at the African Union. On the 11th of February this year, I was on the floor of the Security Council to talk about Africa, about cultural factors in international law. And with that said, the case before you and the case before ICC is an individual criminal responsibility. African Union has not made any complaint here. African Union is concerned about the genocide in Air Germany, El Fasher, that exterminated millions for which General Banda and others are fighting to protect. That is what the African Union is interested on. Furthermore, your honors, about fairness, it was Justice Jackson of Council of US at Nuremberg who said, fairness is not an attribute of weakness. And when we look at these accused, we should be fair to them. Because if we are unfair to them, we'll be like putting a poison chalice to our own lives. The prosecutor in this case has done what he's mandated by the Rome Statute to do. And that's what Africa and the African Union, in particular, the majority in the Rome Statute architecture, 33, and many more now coming, came because they saw the possibility of fairness, a court, instead of the court of the Westphalian orders, the colonial court, they saw a court that will respect the independence of the judiciary, of the judges, protect that independence, guard jealously, and protect the independence of the prosecutor. And that's why we continue to stand resolutely, Africa. And I think it didn't stand because Africa can stand, talk on their behalf. We will respect and protect the independence of this court and the judges and the prosecutor. I will continue to do so resolutely. As we live here and we hear these submissions, the African Union is minded to protect and to say so loudly, because we will no longer be guided by the spirit of Westphalian order that uses the African Union as a faceless institution which can be used to whip out emotions. Your honors, the prosecutor, we agree with the prosecutor in the filing that they made on the 5th of October 2023, in which the prosecutor stated, and I quote, the prosecution is responsible under the court's legal framework for framing the charges upon which an accused is brought to trial. It must also ensure the effective investigation and prosecution of crimes in full respect of the rights of accused, accused persons and of the interests and personal circumstances of victims and witnesses. In discharging these duties, it is incumbent on the prosecution to seek to withdraw the charges pursuant to Regulation 60 of the Regulation of the Office of the Prosecutor if it considers that the evidence does not support the charges in the requisite standard of any stage in the proceedings. A few weeks ago, the Bureau of this court, the plenary of this court, you, your judges, you made a clarification on the question of withdrawal and took a principal decision on which you are acting now. I do not know whether my colleagues actually read the decision that you took about the amendment, the clarification. And I think the withdrawal before your orders is consistent with the collective decision of all the judges of this court to say that the application will be brought before you for withdrawal. Your Honors, I must say something with regard to this specific case. I'm grateful, Your Honors, that you gave me the responsibility to appear before you and defend the interests and the rights of General Banda. You did that. You heard from General Banda himself and made your order that you accepted that he has appointed me and my team to represent him. We will follow the mandate faithfully, ethically, and responsibly. When you ordered that we could contact him, facilitation with General Banda, we did that. And we reported. And we can say clearly that the records of this court, because justice is not just about victims only. They will not understand that we work consistently for years.
Counsel?
Yes.
Chief Taku, please, if we could return to the issue at hand, which is not the review of the efforts to interview your client. Please address your comments solely to the issue of the withdrawal request of the prosecution, please. Thank you.
Well, I take the orders from the court. I was just replying from very emotive submissions, very emotive at the eye, but they did not concern the substance about the powers of the prosecutor to withdraw, which are attribute of fair trial, which make this court strong, that persons outside and victims in crime bases, especially in Africa, where the scholars have been for the past 20 years or more, we know that they will no longer bring cases to the court for trial, which will collapse even at the pre-trial, and many have collapsed. And the prosecutor is right to remedy this situation and bring before you and commit the resources of this court only for cases for which they can secure a conviction or even a prima facie case. The prosecutor has made the assessment, it's wholly within the power of the prosecutor. And I think this is a great occasion in the history of this court that people will know that the prosecutor will prosecute vigorously people against whom they find evidence, individuals, and people that the evidence does not meet the standard, the required standard, to go on trial, the prosecutor will graciously withdraw. Both are victories for this court. It's the discharge of the responsibility of the prosecutor. And I think the prosecutor exercised that right judiciously, reasonably, and I explained it. The prosecutor, I listened to the prosecutor report to the Security Council. There's an additional factor that they said that evidence came to the prosecutor, exculpatory evidence came to the prosecutor, which the prosecutor thought that reviewed in addition to this, I thought that sufficient or was not enough for them to go on trial. And I think we should respect that prosecutorial discretion, that prosecutorial independence. This is what everybody, every justice seeker, that is the original objective of the Rome Statute. We are not going to go to trial just because we want to show a public show. It will bring discredit to the court. And it will be unethical for any prosecutor to put a person on trial when the prosecutor is quite sure that the evidence is not enough. And it is only the prosecutor alone that can make that calling. And the prosecutor made that calling. And your honors, I totally respect that, and I praise the prosecutor for that. I praise your lordship for reconsidering this decision on this basis. Because at some point, even if they brought that case and started trying, and your lordship saw that the evidence was sufficient, it was collapsing, you will have the duty also to say, look, prosecutor, go and look at this evidence and determine whether they intend to continue. Your honors, I do not intend to take as much time as my colleagues to waste the precious time of the court. I only wish to say, I respectfully thank the prosecutor and thank your lordships for giving me the opportunity to defend General Banda. I also thank the witnesses of General Banda, some of them who are under the protection of the court, and many who are there preparing for him to come. When he said he was coming, he changed it to a summons. I thank them, I thank my team, and your honors, I thank the registry that facilitated. For all these years, we're in contact, talking with General Banda. I will file many times. He was always present, showing the interest to come. There were other factors that prevented, but he was always showing. I thank the registry for that. I thank the external operations. And I thank, on the encouragement of your lordship, we held several meetings with the prosecutor external operations with regard to our mandate, and I thank them. And I hope your honors that this is a very good day for international justice. I pass I ask my colleague, Mr. Oreboff, to make other comments.
Thank you, Your Honors. And following the guidance from the Chamber, I have cut 80% of what I was going to say out.
Thank you, counsel.
For everyone watching, for everyone in the courtroom, I would like to make this clear. The problems outlined by my learned colleagues today were problems that existed all these years. They weren't something that came anew. Yes, a few people may have passed away, but we have rules to deal with that. New rules have been instituted in the rules of procedure and evidence. It was because of the perseverance of the Office of the Prosecutor in continuing their investigations and continuing their inquiries that made today happen. And I thank the prosecution for its candor and for its professionalism. Just as we were open during these many years with the Office of the Prosecutor since Chief and I joined in 2019 and constantly contacting them, they were there talking with us, and they were open to the extent that they could be, and they maintained the highest level of professionalism while handling this case and dealing with us with the Chamber, with the Registry, and yes, even General Banda himself. Thank you, Your Honor.
Thank you very much, Counsel. Unless there is any other submissions, which I would not anticipate, this will bring this hearing to a conclusion. The Chamber has heard all the observations and has taken note of them. The prosecution is to take the steps as indicated in the order. Prior to adjourning, I would like to thank the staff, the security, our court registry, court reporters. I'd like to thank those in the public gallery and those who may be following online. At this point, this hearing is adjourned.
All rise, veuillez vous lever.